Hi, everybody. I didn't realize that it was going to be on a stage here tonight. It's kind of fun. I'm Beth Mulcahy, and I'm your presenter here tonight. And I just want to say thank you for coming. I see a lot of familiar faces here and some clients and some other people that have attended seminars before. Tonight we have some really great topics that we're going to be discussing. They're having a little bit of trouble advancing the PowerPoint, I think. And so we're just working out that technical glitch for a minute. But before we get started, I always like to do a little introduction anyways. So welcome to the Phoenix Neighborhood College. As some of you may know, our firm has been partnering with the City of Phoenix for over a decade to provide classes, free education to board members and homeowners regarding community association law. And so I appreciate all of you being here tonight. My name is Beth Mulcahy, and I'm an attorney that's practiced in the area of representing associations for over 20 years. And our firm currently represents over 1,500 associations in the state of Arizona. Just in terms of my background, I'm a native of Milwaukee, Wisconsin, and I moved to Arizona in 1995 and started practicing in this area. And it's been a joy to be in this practice area. It's been really interesting and fun, and I really enjoy the interactions with the clients and solving problems. In addition to my experience as a board member in addition to my experience as a attorney for associations, I also have served on my board where I live, so I understand the trials and tribulations of that. And I also have served as a disgruntled owner in my association. So I have a pretty good wealth of knowledge from many different aspects of working with associations over the years. Before we get started, I do like to always know who is in my audience. So since we have such a small amount of people here today, I love this size group. It's wonderful to have less than 50 people in one room. Because I feel like I can take questions from the floor. Please feel free to, I have a very relaxed teaching style. Please feel free to ask any questions that you'd like and interrupt the presentation if something you have a burning question. It'd be nice for me if you could just give me a show of hands. How many of you are board members for your associations? Excellent. Okay, and how many of you are homeowners that are not board members? Okay, great. So we have a really good mix tonight. That's good. That makes for a good class. I'm assuming that the homeowners that are here want to learn more about associations, maybe because you're worried about how things are being run at your association. Am I guessing that? One thing I can tell you too is that typically if a homeowner is coming to a class like this, guess what's in your future? Someday you're going to be serving on the board. And so that's how I got on my board the first time many years ago, is that I came to a meeting and I had some questions regarding an issue at the association, and before I left, they'd already signed me up to be on the board. So, okay, tonight we're going to be talking about several different subjects, and if the person is up there, would you mind advancing the slide for me? Are they up there yet? I can't see. I don't see anybody. Okay, well, we'll just be flexible. The good thing about teaching a lot of classes over the years, I think I teach over 100 classes during a year, is that you got to be flexible, right? So that's the first thing. The first thing I wanted to mention before we get started, if you look at, this is just the PowerPoint that we have here for tonight. And so everybody has a copy of it, which is helpful, especially in light of the technical difficulties. The first thing I want to mention is we do something called the Mulcahy parking lot. We don't have that many people here today, so we'll still do it. If you have any questions that you want me to specifically address at the end of the presentation, feel free at any time to go over to the parking lot and write them up on the wall. The walls here, unfortunately, are a little bit hard to have the Post-its stick to them, so a couple of them have fallen off, but I also encourage you to ask questions as we go. Okay, good, we got one slide advanced. If we could advance to the next one, please. We did the parking lot, so we'll advance to the next one, please. We already talked about the parking lot, so it's okay if we go to the next one. Great. Just as a public service announcement, we're hearing from a lot of clients that there are homeowners that have not been paying their assessments to associations, and we're trying to help. So we are offering something where if you have any owners that are not paying assessments right now, you are free to email me, and we'll give you a free evaluation of what's the best way to get that owner to pay up. Oftentimes what we find with associations is that they let a delinquency linger for many months or even years, and the sooner that you address the delinquency with the owner, the better, and more likely you are to collect on the debt. I gave you just a little bonus sheet tonight here that's called Secrets to Effective Collection of Delinquent Assessments. If you have any owners that aren't paying right now, this would be a really great informational text for you to look at because it outlines what are some secrets that our firm has to get owners to pay. And then if you have any owner in particular that you'd like us to take a peek at and give you our advice on how to collect on the debt, we're happy to give you our opinion with no strings attached. Right before I came here tonight, actually, I was meeting with a client at my office, and they were talking to me about a homeowner that owed about $1,200 in assessments, and they were wondering what their different legal remedies were to get the owner to pay. And just through a couple strategic internet searches, we were able to determine that the owner acquired the property from her mother passing away. And not only did she own the property, but she also had a very responsible sister who also owns a property. And we also discovered that the property didn't have a mortgage or deed of trust on it. So they own the property free and clear, which is obviously a very good thing because nobody is going to let their property go if they don't have a mortgage or deed of trust on it for $1,200 owed to the association. And so what we did was literally 25 minutes before I came is we looked up the sister's information on Google. We contacted her by phone. We told her about the debt. She was not aware of it. And she told me that she would come to my office tomorrow morning, 8 o'clock when we open, and she would give us a check because she didn't want to have the property be foreclosed on. But just let's say that it didn't work out that way. Remember, under Arizona law, there are really two remedies that we have to collect delinquent assessments. The first remedy is to go and get a justice court judgment against the owner, and that's just a personal judgment. And with that personal judgment, we can garnish the owner's wages. We can garnish their bank account if they have a bank account. How do we know if they have a bank account? If they've ever made a payment to us in the past, we'll traditionally be able to get a copy of the check from our bank, and then now we know where they bank. Or if they're renting the property, we can garnish the tenant's rent. On the flip side, if that typically is for people that have heavily mortgaged properties, we'll go that route. On the flip side is a foreclosure, and that is where the association records a lien and we can take away their property. We cannot foreclose until the assessment is at $1,200 or 1 year delinquent, whichever is first, and that's just assessments. It's not late fees, not attorney's fees, not fines. And in this case, we were threatening to foreclose because it made sense. There's no debt on the property other than what's owed to the association. And we pushed the right lever and we got the sister to pay up, and hopefully she'll be at my doorstep tomorrow at 8 o'clock. Okay, if we could advance to the next slide, please. Okay, we're going to be talking tonight about two different subjects. The first subject is the legislature has provided us with several new laws this year that pertain to associations. And typically, right after the legislation goes into effect, we do a lot of communications with our clients and with seminars of this nature to notify you about what happened. So the legislature opened in January, and this year it really was anticipated that it was going to be a huge legislative year for associations. There are several senators and House members that have expressed anti-HOA sentiment, and they were going to introduce between 50 and 70 bills to further regulate how boards do their jobs. Well, as you can imagine, because the majority of you in this room are board members, and I work with a lot of different boards, I do not think further regulation is a good idea for a number of reasons. Yes, occasionally we do see a bad board where maybe they're making wrong decisions or not complying with the law. But in my experience, 99.999% of the boards that we work with in Arizona, they're volunteers, they're doing their best, they're trying to comply with the law, they're not getting paid, and further laws that they need to be subject to is only going to make them not want to serve on the board, frankly, right? We get enough hassles already being on the board. Just to have to know a whole, additional number of laws and to potentially have minefields if we don't comply with these laws was problematic. So it ended up that we thought it was going to be a big legislative year. In the final analysis, it really wasn't that big of a legislative year. There were three main bills that were ultimately passed by our legislature and signed by the governor. And we're going to be talking about those three bills here tonight. So the first thing is that the bills all went into effect already. They went into effect a couple of weeks ago on August 9th. So these are the current law. So your boards will need to be complying with all of these laws. The first bill we're going to talk about is Senate Bill 1060. So if you could advance the slide for me, please. We have two bills that are I'm mentioning them because I wouldn't want anyone here to leave and say, oh, she didn't know about those two bills. I do know about them, but they really don't have a big impact on associations, so I'm not going to spend a lot of time on them. The first bill is Senate Bill 1060. This deals with the dispute process that owners and associations can engage in if there's a dispute regarding your association's documents or if there's a dispute regarding association's compliance with state law. And basically the history on this law is that about 5 years ago, there was a law passed that said owners and associations that have a dispute regarding interpretation of your documents or state law can go to an agency through the state of Arizona to have your disputes heard. And this agency at the time that they set it up with was the Department of Fire Building and Life Safety. Why they put it with that, I have no idea, but that's how they set it up. So if an association and an owner have a dispute, you can go to the Department of Fire Building and Life Safety and ask for an administrative law judge to hear your case. Now, in my experience, it's mainly homeowners that use this dispute process. And right now, I don't even think we have any in our firm right now. At different times, it goes in waves, but we really only have about 5 or 6 of these a year. And typically what happens is the owner's upset about something and they don't want to go the litigation route because of the costs and the potential exposure. If they lose, they'd have to pay the association's attorney's fees. And so they go to this department, or they were going to this Department of Fire Building and Life Safety, and they would file a complaint, and then the association would file an answer, and then an administrative law judge would conduct a hearing, typically within a few months, and the judge would make a decision. Some pros and cons on going through this administrative law process is that some pros are it's quick. You get an answer pretty quick, and the judges are bright and understand associations. Some of the cons are there aren't a lot of things that you can actually use this for. Like you can't use it for assessment collections. You can't use it for construction defects. Another con is that if you have an attorney, you're not entitled to your attorney's fees. So basically, if a homeowner files through this dispute process and the association hires an attorney, which 100% of the associations that have a complaint filed against them bring their attorney to these hearings, the association could spend thousands of dollars in legal fees, and even if they win, they still have to pay it. So that's a con, but that's a pro from the homeowner side in that there's no exposure other than the minimal filing fee to file this. So anyways, that's the history on this law. There is a dispute process that owners and associations can go to hear complaints. Last summer, just out of nowhere, July 1st, we saw that the complaints were no longer being accepted by the Department of Fire Building and Life Safety, and the Arizona Department of Real Estate started accepting the complaints. Why did this happen? As part of the budgeting process in 2016, the Department of Fire Building and Life Safety was eliminated. And so they had to put it somewhere, so they threw everything over to the Department of Real Estate. And then this year, they made the technical correction to the law so that when owners and associations have a dispute, they now go to the Department of Real Estate. If any of you are in the position where you want to file one of these claims or cases against an association, all you need to do is Google Arizona Department of Real Estate and HOA, and it will pop right up. There's a complaint form. The filing fee has changed almost monthly, so you'll have to see what it currently is. I think the last time I checked it was $500 for one claim, and it was $1,100 for two claims, or two or more claims. Whoever prevails in the proceeding in front of the administrative law judge can ask, to have the filing fee reimbursed by the losing party. So if the plaintiff fronts it when they file it and they win, then the association would have to pay them the filing fee. So basically just a technical correction, and I wanted to make you aware of this alternate dispute process that associations, homeowners are basically using to hear their disputes heard with associations. The next bill is on transfer fees. Just a quick little reminder on transfer fees. Oops. Remember that under Arizona law, the board can charge a transfer fee, and basically they just made some technical corrections to this. Be mindful though that there are different fees that you can charge when there's a new buyer who's purchasing a property in your association. There's some associations are charging a transfer fee. Remember that transfer fee really needs to be de minimis if you are charging it. It's best if the transfer fee language saying that there's a transfer fee that's applied anytime there's a sale of the property, it's best if that's in your CC&Rs. If it's not in your CC&Rs, you can try to rely on the Nonprofit Corporation Act, but we would suggest that you keep that fee very minimal. If you're relying on the Nonprofit Corporation Act, it should just be the cost, whatever the cost would be to change the paperwork for your association. So we shouldn't be seeing like $150, $200, $500. It's more like $25 if you're going to rely on state law. Some other fees that you might be able to charge when there's a transfer of property is a capital contribution fee, and that would be that like the new buyer pays a fee to fund the reserve possibly for your association. That also needs to be set up in your CC&Rs. And then the last fee that's mandated by law is called a disclosure fee. And that is something that is when there's a sale of a property, like let's say that I'm selling my home in my association, basically when I find a buyer and an escrow opens, the title company notifies the association where I live that, okay, Beth Mulcahy is selling her property. Please provide a disclosure statement to the buyer, all information regarding the property. And by law, the information that we are required to provide are all the association's documents so that the buyer knows, what the CC&Rs say, what the bylaws say, what the articles say, a copy of the budget, a copy of the financials, a copy of the reserve study, if you have one for your association, how much money is owed in past due assessments by the seller, what the current assessment rate is, what the insurance requirements are for buyers. It's just basically the 411 on everything this buyer needs to know about the association. And the association can charge a fee for that. Under the law, it cannot exceed $400 by statute. So if we could advance to the next slide, please. Okay, so those are kind of the two bills that I just want you to be aware of. They're, obviously not any big changes in how you're going to do business. But the next bill we're going to talk about is definitely going to be some fine-tuning on the part of your associations to make sure that you comply with it. This bill is House Bill 2411. This bill changes the Planned Communities Act and the Condominium Act, so it applies to all planned communities and condominiums in Arizona. It is going to kind of rework how you handle noticing your meeting, providing notice to the owners about what's going to be discussed at regular board meetings. It talks about mail-in or absentee ballots that may be used for community votes. And finally, we talk about some resale disclosure fees, what's allowable under the resale disclosure law. If you could advance to the next slide, please. Okay, let's start out with the meetings part of this new bill. So for anybody who's been following legislation that's been passed regarding associations over the years, I can tell you that without a doubt, our legislature is very in favor of having open meetings for your board of directors. So what does that mean? That means that the state of Arizona, our governor, our legislators, they do not want boards to be making decisions behind closed doors. Basically, they want transparency. They want the homeowners to be able to listen and hear how the board makes decisions. The legislature wants homeowners to be allowed to participate before the board takes formal action on an item. And one thing, a handout that I brought that I thought would be helpful for tonight, we're going to be focusing on new laws, but sometimes it's really helpful to also talk about what does the current law say about open meetings. So I thought it would be good, maybe we start out with the yellow cheat sheet here. It's our top 10 cheat sheet, the top 10 things people need to know about a community association law. This is number 1 on our top 10 sheet. And just basically a refresher on what the law has been in Arizona on open meetings is as follows. So anytime a quorum of the board or a committee that has regularly scheduled meetings, so anytime you have a quorum of the board or committees that have regularly scheduled meetings, meet to discuss association business, it needs to be an open meeting. So if your board has 5 members, if 3 members get together and you're talking about the board and board issues and homeowners and issues that are facing your community, it's a board meeting. And if it's a board meeting, then it needs to be properly noticed. You have to give 48 hours notice to the members that you're conducting a meeting. And that notice can be really, the law doesn't give us a lot of direction. It could be on your website. It could be conspicuously posted at your property. It could be an email notice to your owners that we're having a board meeting, on Monday night at 7 p.m. at the pool. You could send out 1 notice a year saying all of our meetings are the 3rd Friday of the month at 9 o'clock. Whatever your means are to get the word out about the meetings, you need to give 48 hours notice before the board has an open board meeting. Another important thing to know about board meetings are that homeowners are allowed to attend and listen and participate before the board takes formal action on an item. Now, how most boards set up their board meetings are that they give the proper notice 48 hours in advance. Most of my clients right now are putting it on a website for the association, or they are posting it at the property, or they're sending out an email to the owners. And then at the meeting, typically what they're doing is they're having an owner forum before the meeting, before the board starts conducting the business of the meeting. And if you have any owners that come to the meeting, they should be allowed to comment on something. And it just depends on how many people want to comment, how long they should be able to talk, but you want to be nice and respectful of people that come and want to share their thoughts about your association. And then the board enters the formal board meeting, and then the homeowners really don't contribute very much unless the board is taking action on an item. And by action on an item, I mean if the board's voting on something. If a homeowner wants to contribute before the board votes on something, during this discussion period, after the motion is made, I move to hire ABC Landscaping. There's a second, and then you go into discussion. During the discussion period, the homeowner can volunteer whatever comment that they want to make about whatever item is being discussed in the motion. We don't see homeowners exercising that right very often, but you do have that right as a homeowner, just so you know. The board can go into what we call executive session, and again, this is just the current law, and executive session is just the board, no homeowners. And you typically go into executive session to talk about delinquencies, violations, advice from your attorney, those type of things. And so that's basically just the rundown on open meetings. I will say this, I've been practicing in this area since 1995, and I can say that without a doubt, the legislature continues to fine-tune this law. And they continue to believe that there is not the boards are not operating in a transparent manner. And so they want to make it unequivocally clear that, okay, if your board is making, if your board is voting on things and you have a quorum of board discussing things, it needs to be an open meeting. Yes?
Is there a limit to the number of executive meetings that the board can have in a year?
No. The question is there a limit to the number of executive sessions that your board should have in a year? And I would say no. Typically most boards have an executive session every month. Most boards are meeting monthly. And maybe they take July off and December off because they can't get a quorum due to the holidays and vacations. But most boards are having an executive session. Typically, it's either right before the meeting starts or right after the meeting ends, the regular meeting. And it's short, 5 minutes, 10 minutes. If your board is having an inordinate amount of executive sessions, that's probably not a good sign. I'll share with you, my experience. So I said I'm on my board. I'm the treasurer of my board right now. And we were having an executive session every month, basically, before our meeting started. And we had 2 homeowners that came to the meeting, and they both actually were former board members. And they said, we don't like that you're having so many executive sessions. And, I guess my comment was, if there's unrest or upset about this, we'll move it to the open session. We were talking about delinquencies, basically. And so now we just don't use the lot numbers or the homeowners' names. We just talk about it, what's the next step we're going to take. And we haven't really had any issues where we had to go into executive session. But there are times where you will have to go into executive session. Like, let's say you've got a homeowner that's suing the board, or vice versa, the association suing a homeowner. And now we're at the stage where we're talking about settlement of the lawsuit and what our likelihood of success is. That's not something that should be open for other homeowners to hear and then report back to that homeowner. I guess if I'm advising associations, the associations we work with, I'd say try to limit the number of executive sessions you have, because people do have a sense of uneasiness that the board is talking about things that aren't part of executive session subjects. And you're going to see in the bill that we're going to talk about here, the legislature is catching on to that now. And before we go into executive session, we have to announce specifically which section in the executive session meeting law we're talking about that night. And then we can't talk about anything else other than what we publicly disclose we're going to be talking about. So we'll talk about that in a minute. Yes?
The bylaws state shall have a meeting every month. Does that mean they have to have a meeting every month?
They should make every effort to have a meeting every month. If it says, yes, you shall have a board meeting every month, but if you can't get a quorum, you can't get a quorum. So there may be times where, you make an effort to have it, but you don't have enough people for a quorum, so the meeting just doesn't happen.
Can a meeting happen with 5 members? Can a meeting happen with 1 or 2 members of a management company present?
It could be an informal meeting, but there would be no decisions being made because you don't have a quorum.
But the document says shall have meetings, so it should be a meeting.
But technically, it's not a meeting unless you have a quorum. That's the only way you can have an official meeting.
My other question was, if the documents also state that when a board member misses 3 meetings, they have to be taken off the board. If they miss meetings because there's 3 months in a row where they said they didn't have a quorum, it's thrown off the board.
Well, I have to see specifically your documents on that. But one point I want to make before we even go there, like I said, I'm on my board. I have appeared, let's see, I think I had to do last month's meeting telephonically because I had another commitment and I was driving somewhere, so I had to appear telephonically, and that's perfectly legal under the law. So if you have people that are saying I can't attend, try to, especially if they're traveling in the summer months, you could have them appear telephonically. I've done 2 meetings, I think, in the past 8 months telephonically because I had to. I had no other choice. So that might be a way to help you get a quorum. Now, here's your next question. What if our bylaws say if a board member misses 3 consecutive meetings, that they automatically resign their position from the board. We see that in older documents, antiquated documents typically. So I guess your question is, let's do it first from one analysis. Let's say you've got a board member who never comes, right? It's horrible. We have that actually, unfortunately, at my association right now. It's horrible because it puts the pressure on the rest of your board. I can never miss a meeting. That's why I'm appearing telephonically, right? Because without that person ever showing up, it's a problem. So one good thing is you're lucky you have that provision, because it's a way that you can have that person automatically resign. If they're not coming, you have procedures in your bylaws where they're off. Now, to answer your question, they would actually have to miss a meeting. In your situation, there hasn't been a meeting because there hasn't been a quorum. So you haven't missed a meeting. So nobody has to resign in that situation. Okay? There was a question in the back. Do you still have it?
Yes. Can you touch on directors' communications by email?
Yes.
Amongst
Thank you.
themselves?
Awesome. Thank you so much for bringing that question up. So the question is, can you touch on use of email by board members? What's acceptable, what's not acceptable, what's in violation of the law, what's not? This is really kind of a sticky wicket. Because I know I'm on my board, right? And I get copied on a lot of stuff as legal counsel for associations. Boards are making decisions by email often, right? And when you look at the law, what the legislature is saying is that, hey, that shouldn't be happening. They're not mentioning email exceptions. They are saying that all decisions that are made by the board need to be done during an open board meeting. There is one exception under the law, and that is emergency meetings. The law specifically does allow the board to conduct an emergency meeting when emergency circumstances dictate. That would mean that the board has to make a decision and they can't wait 48 hours to notice it. So you can make decisions by email in an emergency situation. What the law requires is that you read into the record what the emergency was and how the board acted at the next regular board meeting, so there's a paper trail on it. You can also have an in-person emergency meeting of the board if that's possible, based on where everybody's physically located, and then take minutes of that meeting if you do have an emergency board meeting, even if it's less than a quorum, and then at the next board meeting you'd read into the record what was decided. But what about all that other stuff? Like, I'm going to go home tonight and I'm going to turn on my email, and I'm going to have been copied on a lot of emails between board members, right? And so what's okay and what's not okay? So know that our legislature feels that everything needs to be done in the open board meeting, right? Know that. So when can you use email to communicate as a board? It's perfectly acceptable to use email to exchange information, such as, I did some research on landscaping companies. Here are, links to their websites, or here are 3 bids. Let's discuss this at the next board meeting. That's okay. Communicating between yourselves to determine when you can meet. Definitely, everybody can say, yes, I can come, no, I can't come, that's fine. Deciding to terminate a vendor or hire a vendor by email, probably not a good idea, because you're really supposed to be doing that in an open board meeting. If you're walking on thin ice and doing that now, I very strongly suggest that anything that you do in between meetings by email, that the first thing on the agenda is a consent agenda at your next meeting, and just consent to any decisions that you made outside of the meeting by email. Vote on it then, reaffirm the decision. It's not perfect, and if you have a homeowner that questions that, the decision should have been in the open meeting, not by email, so you probably have a problem. One other thing I do want to mention is that in the past, we had publicized, and so had every law firm that practices in this area, that it was okay for boards to make decisions via unanimous written consent under the Nonprofit Corporation Act. So there's a law, most associations, like 99% of them, are considered or are nonprofit corporations. And if you're a nonprofit corporation in Arizona, there's a law that specifically applies to you called the Nonprofit Corporation Act. And in that law, it said that boards could make decisions via unanimous written consent. So if you have a 5-member board, if 5 out of 5 voted on something, didn't have to be done at the meeting, it could be done outside of the meeting by email, relying on this Nonprofit Corporation Act. Well, over the past 12 months, we've now seen 2 judges in administrative law hearings say, you can't do that, associations. The open meeting law trumps the Nonprofit Corporation Act because it's more specific with regard to what you can and can't do in an open, meeting. And so my advice to you is be very cautious about using email other than for emergencies, other than for exchanging information, other than scheduling meetings. Just be careful. If you are doing that, you are making decisions by email, and it's not those 3 categories, please use a consent agenda at your next board meeting so that there's a paper trail in an open board meeting that the decision was reaffirmed. Okay? Yes, and I'll come right to you, ma'am. Yes.
On their site, the Office of Administrative Hearings, you can see all the decisions. And there was a current decision where a homeowner took them to a hearing because they did an email decision. And usually it's $200 or $500 fine besides the filing fee. And she asked the judge for a $10,000 fine, and he agreed to a fine of $10,000.
Yeah, that's one of the cases that I'm talking about. So, be mindful of it. Well, first of all, don't get yourself in that situation. If a homeowner files one of those claims against you, right away, please, resolve it with the owner. If you've made a mistake, make it right, apologize, re-vote on the decision in an open board meeting where there's homeowner input is allowed, and try to fix it if you can. In that particular case, the association unfortunately had a history of doing this, and I think that's why the judge came down really hard on that particular homeowner, on that particular association. So be mindful of it. You have to be careful. Yes? Oh, I'm sorry. Can I go to her first and then I'll come right to you? I'm sorry. You're first.
I don't know if I'm understanding this right. Anything that's like a vote that applies to the whole community, everybody.
Anytime the board is taking a vote, or anytime the board's discussing association business, voting on spending association money, that's a board meeting. Anytime that a quorum of the board is doing that, it's considered a regular board meeting.
So that has to be open.
Yes.
But the executive is just basically lot specific, usually.
The executive session, typically you're talking about violations on a lot specific, delinquencies on a lot specific, or maybe advice from your attorney on any issue. It could be a violation.
But no votes should be going that apply to the whole.
You can vote. The board can vote during executive session. Absolutely. There's separate minutes that are taken, and the board does take votes in executive session, and those minutes are never disclosed to anybody, just the board.
Okay, but shouldn't the topic of those votes be?
Well, we're going to talk about that in a minute. So hold that thought. I'm going to go back to him, and then we're going to get right into what the new law says. Yes?
I was just thinking about that whole appeal process. That it really is not, if you're the board, you don't want to get involved and end up spending a fair amount of associations in terms of spending yourself. So the dynamics are, unless it's a critical issue, you want to go fix it outside of
I mean, I generally speaking, yes. When you get involved in, I've kind of coined this term for associations and how we practice law. We try to give advice that's preventative legal, okay? There are occasions where you will get a homeowner who is not reasonable, and there is nothing we can do to get that person to comply or to be reasonable or to work with us for a solution. In those situations, litigation is unfortunately the only alternative, or maybe going to the dispute process. But most disputes can be resolved, we found, by just working together, right? I mean, I don't know if any of you saw the article. There was an article that was all over national news today about an owner in Colorado who had an association. He He lives in an association. His association sent, he's retired and retired to Colorado. His association sent him a violation letter for some objects being in his yard. And I saw the picture. It looked a little bit junky, but it wasn't horrible. Okay, it was a little bit junky, but it wasn't hoarder quality, okay? And so this particular owner got very upset. By very upset, I mean he went to a sign store and had a sign made, painted out of wood, that is about, maybe half the size of this PowerPoint, the white on the PowerPoint, and if you turned it the other way. And it basically said, don't buy a home in this association because you will become a target of the HOA. And it's had a lot of really derogatory things about the association. And, it made national news. And I was thinking to myself as I was reading the article this morning, I've been doing this a long time, 22 years. When we send a violation letter as a board, 95% of the time, an owner's just going to fix it, right? You're not going to hear anything. They're going to remove the extra items. The matter's going to go away. But maybe 5% of the time, you're going to get an owner like this guy in Colorado who is going to get really bent out of shape about this, okay? And there's two paths you can take. One path is everybody puts their back up. I'm right, you're wrong. Let's go to court. Let's put up a sign. Let's be on national news. Let's trash our property values. Let's, remove the board, whatever. I mean, it's going to turn into an escalated, don't turn back. Let's burn all the bridges. Let's ruin our association. Let's have everybody fighting. You can go that route. Or you can go a little bit more reasonable route and try to work it out with the owner. And there's always that fork in the road. So think about preventative legal the next time you're at that fork in the road and try to figure out what's going to be a good solution. I hate to keep telling stories, but I think stories do help. So we've got the guy with the sign, right? Something went wrong there. Somebody should have picked up the phone and said, listen, Mr. So-and-so, I'm sorry that our letter wasn't received in the manner that we intended it to be. We're sorry that we offended you in such a profound way. Can we work together? We don't want to have all this animosity in our neighborhood. Can we work together to, maybe move some of the items to your backyard, or can we help you in some way so that we can make this a win-win for both of us? And guess what? It probably would have gone away. The last sentence in the article that I read this morning, this guy is willing to bet the house on this case. I mean, how ridiculous. He's retired. He shouldn't be doing that. He should be having fun, right? Not fighting his HOA. So, just think about that when you get to the fork in the road. Preventative legal sometimes is really a very smart way to go, because we all know if it escalates up into full-blown litigation, it's very, very expensive and it's exhausting, and you lose board members because they just don't want to deal with it anymore. I'm not saying don't back down if there's truly a violation you can't live with, but try to look for some solutions. If you've got somebody who's somewhat reasonable on the other side, hopefully you can resolve it. Okay, let's talk a little bit. Did I answer everybody's questions? Yes, one more.
I do have one more.
Mm-hmm.
And I'm not sure if it pertains to this here, or if it's going to be discussed later on, and you can tell me.
Sure.
Okay. But is the board allowed to rearrange its members without an open?
By rearrange members, meaning like
vote?
they're doing like a position switch, like the president's going to become the secretary or something like that?
Somebody's term is about to expire, so they switch them to another position.
That's a really good question. That's a very good question. Okay, so the question on the table is, can our board switch terms? So like, let's say I'm elected. I was just elected to my board in December of last year, 2016. I have a 3-year term. And let's say that the board really wants to keep me on, right? Free legal advice. So they want to keep me on the board. So let's say that somebody else, another position opens up, and I've already served, let's say, 2 years of my term. They want to switch me over to another person's 3-year term. Is it legal for them to do that? Yes. I mean, so let's say basically what they would do is they would appoint Beth Mulcahy to fill the vacancy created, that's a 3-year term or whatever. Is it a good idea? Probably not. So there's different, is it legal? Yes. Typically most boards have the legal authority in their bylaws when there is a vacancy created on your board to appoint somebody to fill that vacancy. So from a purely legal standpoint, what they're doing, they have the right to do that. Is it a good idea? Probably not. It's very confusing. I have been involved in untangling that mess because the paper trail is usually not very good. And then then we don't know how long Beth Mulcahy's term is, right? And that's a lot of confusion. And management companies change, board members change. I really think the better approach is for you to serve your term, and if it's time for you to be reelected, if you're doing a good job, the homeowners are going to reelect you anyways. You don't need to, jury rig it so that we keep people on for long periods of time or whatever. You should be confident enough in your ability as a manager, or as a board member, and frankly, it's a volunteer position, that just let course run itself, would be my advice. But I can't say that I haven't had boards that have done that, because I have. Yes?
In this situation, when you are elected, and so the terms then are,
The terms are defined in the bylaws.
right, but I mean, are they the person or the position? I mean, how can you, if you're elected and you're appointed to a 3-year term, and then 2 years later you're
Well, what you would need to do is you would need to formalize. So the question is, you're elected. So let's give my example. I was elected in December for a 3-year term, right? And let's say that next December, in the meantime, we've got another election, somebody else gets elected, they get the 3-year term. I'm down to a 2-year term now at that point. I would have to resign from the board. You have to do it in the minutes. And then they would have to appoint me to the vacant position's term. So it's messy. That's why I said I don't like doing this. It's
term is more for the position rather than the person?
well, the person and the term stay together, but to make it so it's clear for you, I would have to resign the balance of my term as a director, and then I would be appointed to the other one. But again, I don't like this. Nobody ever does it right, and then it just becomes a nightmare in about 6 years when we're trying to figure out whose term is whose. It becomes very sticky. So really good question. Okay, let's talk about what's the new laws that the legislature gave us this year on open board meetings. As some of you may be aware, owners are allowed to audio or videotape board meetings. The new law this year says that associations cannot require advance notice of audio or videotaping board meetings. Apparently, some associations were requiring like 48 hours notice be provided to them before the homeowners could audio or videotape the meetings. That's not going to be allowed anymore. So a homeowner can show up. I was just at a meeting Tuesday night where we had a homeowner pop out a phone. They started videotaping the meeting, and that was that. Okay. Number 2, the board can pass a rule prohibiting those attending a board meeting from videotaping the board meeting if certain conditions are met. So the law says you can audio or videotape a meeting, but it also says that the board can say, no, you can't, but only if the board is audio or videotaping the meeting themselves, and then they make that audio or videotape available at no charge to the owner, unedited, and that audio or videotape that the board took can be used in future proceedings, litigation, as evidence as to what happened at that meeting. So just kind of a weird law. I have no idea why they would pass this. Yes?
The owner shows up and they're auto taping it, and you don't tell people at the meeting, that's okay, or do they have to tell people what they're doing?
Well, there's nothing under this law in the Condominium Act or the Planned Communities Act that makes it mandatory that owners, say, I'm taping everybody, here's my camera. Usually you can tell because they either have, if they're videotaping it, they're holding up the phone and you can see, what they're doing. If they're audio taping it, usually you can't tell. But in order to have a high quality audio tape, you really have to have it next to the person that's speaking. So it's going to be a lot of mumbled noise, and it's not going to be a good, it's not going to at all be a good audio tape of the meeting. It does kind of make sense to have the board do it, but I don't have any boards that are currently exercising this. The law just went into effect August 9th, but I don't have any boards that are saying like, oh yes, we're going to do this now. We don't see audio or videotaping that much. Typically when it comes into play is when an owner's upset about something and they come and they want to audio or videotape the meeting to, use in future litigation or whatever. Okay, the third part of this new law is that the notice of any regular board meeting, special meeting of the board, or special meeting of the homeowners, or any annual meeting must now state the date, time, and place of the meeting. Now, in my experience, most boards are already doing this. So any notice that you put out of any meeting for your association, basically, so regular meetings of the board, any special meetings of the board or your association members, or the annual meeting, have to have the date, place, and time for the meeting. Let's see. One other thing that we also have to do is it also has to state the purpose of the meeting. This is definitely new. This is something that most boards haven't been doing in the past. Most boards have just been saying like regular board meeting, 7 p.m. at the pool, August 29th, whatever. Well, now you need to tell what the purpose of the meeting is. And so our firm is suggesting that the best way to comply with this is to provide a copy of the agenda as part of the notice. Actually, the agenda could be the notice. You could just state at the top, the meeting's going to be held at 7 p.m. at the association's pool on August 29th, and then have the agenda. Now, for those of you who are seasoned board members, you know that the agenda basically stays the same every month with a few exceptions. So it should be pretty easy to put the agenda out there. You might want to put some open-ended things on the agenda like new business, old business, because we all know things get added to the agenda for board meetings at 4 p.m. when the meeting's at 6 p.m. that night. So have some open-ended agenda items on there. If you're going to be voting on anything that could be challenged legally down the road, make sure you state with particularity on the agenda that you're going to be discussing the bylaw amendments, and you may even want to give owners a copy of the bylaw amendments before the meeting so they know what the changes are going to be. Okay, if we could go to the next slide, please. Yes?
Question. If you just have, like you said earlier, just notices sent out once a year or whenever, that you're having a meeting the second Tuesday of the month or whatever, then how can you put the agenda with it?
Well, that's true. So you could either do a very broad agenda, but I don't think that that's going to necessarily meet the specific requirements of the law. Or you could just put out the agenda, in advance, 48 hours in advance, each month that it changes. One way, just an absolute minimum, compliance with the law would be to say that these are the typical agenda items for every meeting, and that any changes or additions to them will circulate an agenda for that particular meeting if there's going to be any changes. Okay, I think I lost my person who's flipping my my stage crew. I think they may be in the restroom, so we'll just flip and go to the next page. So we're on the PowerPoint pages. We're on page number 5. And if she's there. Okay, good. Thank you. I can't see you anymore. There you are. Okay. Let's see. I think we got to go back one. Sorry about that. Okay, good. What are some other changes to the open meeting law? Another change is before you enter executive session, you have to announce and identify the section that authorized the board to close the meeting and go into executive session. And as a reminder, there are 5 topics that you can go into executive session for. And those topics are number 1 here, legal advice from an attorney. Number 2, pending or contemplated litigations. That's going to be like violations, delinquencies. If we could advance to the next slide, that'd be great. And then personal health or financial information about an individual owner, independent contractor, or an employee of the association. We really hardly ever see this for executive session. Matters pertaining to the job performance of, compensation of, or complaints of your vendors or your employees. We don't see that very often either. And then if a member wants to have their appeal, let's say that there's a violation on their lot and they want to have their appeal, the board can put this in executive session, having the appeal be heard by the board. But if the owner wants it in the open session, then it gets moved to the open session. So the bottom line on this part of the law is, okay, before you go into executive session, you need to announce which categories of the executive session law you're going to be discussing during that executive session. And a really good thing to do is get back to that agenda, put on the bottom of the agenda that you have for the regular meeting, that immediately following, or maybe it was immediately preceding, if you do your executive session before, the board will be going into executive session to discuss. And then just state, the topics that you're going to be discussing. Keep it simple. Typically, the boards that I see go into executive session, it's legal advice from your attorney, delinquencies, and violations. Those are the 3 things I always see. Yes?
Who is considered a vendor?
Who is considered? Well, there's different kinds. So some associations have direct employees. Like, let's say you have a handyman that is on your payroll, you pay, for workers' compensation insurance, that's considered a direct employee. A vendor would be an independent contractor, like a landscaping company or a management company are the most common vendors that we would see. But if you have any special projects, like a roofing company that's doing re-roofing, or asphalt company, or pool contractor, those are some other ones that we'll see for different associations. So if you're discussing their compensation, their performance of their job, any complaints that may come up about a vendor, that could go into executive session if you wanted to. But sometimes it's a good idea to discuss that in the open session, because homeowners are coming to the meeting upset. And if you're not discussing it in the open session, what you're going to do, we're going to talk to the contractor about why they didn't show up or whatever. If you're not talking about that in the open session and you're talking about that in the closed session, the homeowners might think that you're not doing anything. So you might want to just move that to the open session. Yes?
Now, also, let's use the management company as a vendor.
Okay.
Okay, as an example. If they're talking about changing management companies, should that be done in an open session, or is that executive?
So really good question. So if you have a management company and your board is thinking about switching, making a change in the management company, is that an open session or an executive session? Well, first, it's not mandatory that the board has to go into executive session. Okay, it says may. It doesn't say shall. It says the board may go into executive session. So it's up to your board if that's something you want to discuss in the open session or the closed session. Now, if you're going to be discussing that in the closed session, the executive session, you really need to be talking about their job performance, their compensation, or complaints. Okay, so that's it. On ABC Management Company, we're thinking about firing them. Why? You can go over the reasons in executive session, the complaints, their performance. Now, when you go to fire them, that needs to be done in the open session, not in the closed session. Also, when you're interviewing new management companies and selecting a new management company, that needs to be done in the open session as well. And that's for any vendor, not just a management company. Okay? Yes?
My question is, are we required to announce that we are going into an executive session at the end of each open meeting?
If you're going into the executive session after, yes. And one way to announce it would be just to put it on your agenda. Okay. I mean, what we're saying, just to be extra careful to our clients, is put it on the agenda, the reasons why you're going into executive session and that you're having an executive session. Have the minutes reflect as well that you're going into executive session and then what for. Your minute taker should just automatically put that in just to protect us going forward. And then the president should also announce it, just so people don't, get the wrong idea that the board's kicking everybody out, and going to discuss things when you're not there. Okay, if we could advance to the next slide, please. Okay, another part of this law talks about emergency meetings. Now, we talked a little bit about emergency meetings with the question in the back from you. The board also the legislature has also given us some additional direction on emergency meetings. And it says an emergency meeting of the board may be called to discuss business or take action that cannot be delayed for 48 hours. We were already following that, but now they've put it in the actual language of the statute. Any emergency meeting called by the board of directors, the board may only act on emergency matters. So it's not the time to bring out the flowers at the front entrance, right? You stick to, when you have an emergency meeting, you stick to only the emergency being discussed, you take minutes, and then at the next regular board meeting, you read into the record what the emergency was and what action was taken. Okay, so that just gives us a little more direction on how emergency meetings are going to be handled going forward.
Okay, so say one of your swimming pools develops a bad leak, okay? And so the pool is going to have to be drained in order to fix this bad leak. Also, this pool needs to have the drains adjusted due to new rules and regs that go into effect about the drains in the spa being 36 inches apart. Is that considered an emergency session? Because if you're draining the pool and sometime in 2000.
Yes, I would say that if you're dealing with, an emergency maintenance issue, which basically you're dealing with a pool leaking, and if you need to address the drains while the pool is being drained, yes, I think that can be discussed.
Okay,
Yeah.
great, thank you.
Okay, yes.
That's kind of where my question is. So for example, it's on one of the scales. For example, we had a leak and we just got it fixed rather than that. We had some need to fix it. It was a bad leak, just fix it. So where do you draw, you know what I'm saying? It seems like there's a critical mass. If they can't wrong, maybe we should have emergency meeting about what we have.
Not necessarily. A lot of boards give leeway on issues like maintenance issues that come up from time to time, especially in the summer when board members are typically traveling a lot. And so just as your board, communicate with each other, and say, listen, if there's any sort of a maintenance issue at our association and it's under $2,000, do I, whoever is the key person on your board that's handling this, do I have the authority just to get it fixed and get it in the minutes? And then when you do it, just send an email to your other owners or to the other board members saying, hey, just so you know, we had an issue with the spa. We needed to change the fan, whatever. I handled it. Just letting you know, FYI. You're not asking for a vote. You're just letting them know that you acted within the scope of the authority that they gave you. And a lot of boards Band-Aid their summers that way because they can't get a quorum. They can't reach people. And the people on deck in Arizona are handling a lot of the fires that are coming up. And that's perfectly legal. Just make sure that you have your scope of authority in the minutes so that everybody knows what you have authority to do, okay? And for the most part, most boards never have a problem on this. No homeowner ever challenges them. But every once in a while, you'll get a homeowner that'll say, well, where's the authority for that? And if you're gonna go by the black letter of the law, under the open meeting law, it needs to be in the minutes. So also one other thing you might wanna do is if you're the president, have a president's report in the minutes. And it depends on how long it is, but you could just attach it to the minutes. Just read into this month, this is what we accomplished, and then just attach it to the minutes. So then it's clear what was done. Do you know what I mean? So if anyone ever challenges it down the road, there's a paper trail in your president's report as to what you did. Okay, let's switch to the next slide, please. 2 more very minor parts of this law, and then we'll move on to amending associations documents. Okay, I'm not even going to read this whole paragraph, but this is just another example. I lifted this exactly from the new legislation. It's basically that it's the policy and intent of the state of Arizona that all board meetings need to be open board meetings, okay? So just reiterating that to us. One other thing that I thought was really interesting, and I underlined it here, it also is extending the responsibility to comply with the open meeting laws now to managers. That's the first time we've seen that. So it could be opening up a liability drawer for managers that don't have their boards complying with the open meeting law. And so just kind of an interesting tidbit. I put this in there because it is part of the new law this year. Okay, if we could go to the next slide. 2 other parts of this law. So last year there was this crazy bill that was passed that said that anytime there was a ballot that was used to vote on an association issue. So let's give an example, like your annual meeting ballot where you elect directors, that the ballot had to have the name and it had to have the address of the owner and the signature. Okay, I'm fine with that on the ballot. But in addition to that, last year, it also said that the envelope that the owner returned the ballot in also had to have their name, their address, and their signature. Well, I can tell you, I go to annual meetings all the time, at least 2 or 3 a week. Nobody was doing this right, okay? None of the homeowners were signing the envelope. Of course, they're gonna sign the ballot, they're gonna put their name on it, they're gonna put their address on it, they're gonna sign it. If it was a secret ballot, you know, they weren't going to sign the ballot, they would sign the envelope, and most people got that if you're one of those associations that requires a secret ballot. But for every other association that has always not used secret ballot, to have a signature, name, and address on the envelope in addition to the ballot, people just, they weren't doing it. And it was causing a lot of problems because we were wondering, can we count the ballot if they didn't comply with this? Well, good news. Our legislature woke up and they took out the requirement for the envelope to have the name, the address, and the signature on the envelope. So effective now, you don't have to do that anymore as of August 9th. The last thing is just a kind of weird law. You always, whenever you get these laws, you're like, oh, I bet there was an association that was doing this. So anyways, remember we talked about the resale disclosure charge and information that associations can charge $400 to provide to buyers to tell them about the association when a property enters escrow. Well, apparently some associations were charging the $400 maximum for the disclosure statement, and then they were adding on a delivery fee. I don't know how much they were charging, but the legislature didn't like that. So they said that the maximum you can charge for the preparation of the disclosure statement and a delivery fee is $400. So notable, I just thought I would mention that.
Is that charge just arbitrary by an association? Or do you actually like prove what you spent for these documents?
You don't count pages, it's arbitrary.
Okay.
So most associations, just so you know, are charging the $400. Most associations in Arizona right now, in my experience, are charging the maximum. Okay, let's switch gears now. We're going to talk a little bit about our next subject, so we're going to flip to the next slide, please. The next subject is amending association documents, and it's okay just to swing right through to the next one, too. So recently, our firm had like a little summer project where we went through all of our clients' documents, and we did a little housekeeping, and we determined that over 80% of the associations we work with have documents that are more than 10 years old. And what that means is that a lot of your association's documents are antiquated, are not consistent with what Arizona law currently states because the laws are changing every year. And so a very common question that I get is, how often should we be updating our documents? You know, and I think it's really a personal choice for your board, but if you've gone a decade or more without having an amendment to your documents, it really is time for you to be thinking about, hey, should we be looking into, you know, updating, cleaning up our documents, making them in compliance with Arizona law so that it's not confusing for homeowners, you know, because the laws have changed so much over time that your documents probably say you can do one thing, but really you can't do it anymore under the law, so it's very confusing. We get a lot of phone calls from owners saying, the board can't do this, it's right in our documents, but then we say, no, under the law, you know, the law changed in 1998, and the board now can do that, and then they never believe us, so then we have to send them the law, and then the next question is, well, why hasn't the board changed the documents? So it's kind of a vicious circle. A couple things to remember. I know I have one client here that has documents that are very difficult to amend. You know, you have to look at, is it even possible for us to amend them? That's a very valid concern, because there's a cost to amend your documents. You know, there's a paper cost, there's a mailing cost, there's legal costs, and it takes time and effort to do it. So if you have a really high percentage, like a 90% or 7/8 or whatever, I mean, you really want to think about, is this something that's even possible when we're going through the strategy about, do we want to do this? That's something that you should get advice from your attorney on. Okay, so what are the most common reasons to amend your documents? In our experience, to delete or modify restrictions that are outdated, things that don't apply anymore. There's probably a ton of mortgage language that is no longer required, developer language when your developer is long gone. Maybe your documents are unreasonable or ambiguous. I have an association right now where they get to interview every new buyer that comes into the association. And it actually says if you don't like the buyer, you can kill the deal. Now, I can tell you right now, that's against the law. So that's the type of thing. And now mortgage companies are picking up on it and saying, we will not write a loan in your association because you have that provision in there. So, and there's all kinds of examples of this. I mean, there's the satellite dishes and antennas law, the OTARD rule now allows owners to have, you know, satellite dishes and antennas that are under certain size requirements. And there's solar laws now in Arizona that say that associations cannot effectively prohibit solar energy devices. And I mean, sometimes we see discriminatory language in the documents that really needs to be removed. So,
How do you define unreasonable?
Unreasonable, well, you know, maybe we'll see something in the documents where it'll say that, you know, only a certain number of units can be leased at any one time. Well, how do we determine which unit can be leased? You know, and let's say, you know, I have actually a complex that has this right now, and so they say only 2 out of the 10 can be leased at any one time. And there's been one owner that's always exercised the 2, right? And now there's a third owner that wants to lease their property. And they're saying, what we're saying is, okay, the documents say 2. Now we've got, you know, another person that wants to do it. You know, this language, in my opinion, is unreasonable. There should have been some sort of a lottery description as to how the property could be leased, you know, which 2 would be selected, et cetera. And so just randomly having somebody, the first person in to lease, and then having a life, you know, being able to do it for as long as they own the property doesn't seem reasonable to me. Also comply with federal, state, and local law changes. Delete or modify provisions that are inconsistent with the management and operation of the association. Maybe you have a provision in your documents that says that everybody in your association has to have the same front lanterns or the same lighting, you know, exterior lighting. And guess what? Over time, 80% of your owners have changed and it's not all the same anymore. And so you might want to correct that and just say that it needs to get, you know, architectural approval before an owner would change the lantern. Getting rid of developer language, correcting provisions that conflict with other sets of documents for your association. This is a very common problem. You have an association where it says the CC&Rs say you have 3 board members. The articles say there should be 7, and the bylaws say there should be 5. It's like, which one do we follow, right? Fortunately, state law does tell us that the CC&Rs come in first priority in terms of, you know, trumping everything else, and then the articles, and then the bylaws, and then the rules. But it's confusing. You know, we don't want to have our documents all stating different things. Let's see. So one thing we suggest is if you're going to do a document amendment, make sure you have a strategy for it. It's not an inexpensive process. It's not the easiest process, but it is once you do it, then you'll know we don't have to do this again for another decade. So we're going to give you a good strategy here that's worked for a number of our clients. So if you could switch to the next slide for me, please. What we've done is we've broken it up into a 5-step plan, and basically I've done personally amended thousands of sets of CC&Rs over the years. This is the formula that works. If you try to skip a step, it ultimately may cause the entire process to fail. So this is really like when people give you a blueprint for success on amending your documents, this is a very, very helpful blueprint. So the first thing is figure out what's required to amend your documents. That's the first step. Typically you'll look towards the end of each document, there's an amendment provision, and it'll say like you need 67% of the owners or 51% of the owners. Sometimes it has tricky language like 51% of the owners present at a meeting where a quorum is present, or something like that. So you really want to analyze what exactly do we need. And then you also want to counter check it with state law, because if you're a condo, you can never go under 67% of the owners. And so if you're a condo and it says 51%, state law trumps it, so you want to go by what state law says there. So get some advice from your attorney at this point. Most documents do require approval of your membership, so it's not something typically that your board can change without membership approval. Let's see, in some rare cases, the board can amend the CC&Rs, but it's really rare. Let's see, typically the rules are promulgated by the board, so you don't typically need membership approval of the rules. Make sure you're running your rules by your association legal counsel before the board approves them, because sometimes the rules, conflict with other documents, and sometimes the rules are arbitrary and discriminatory on their face. You want to be real careful you get somebody with some expertise to review them. Okay, let's go to the next step. One other thing I want to mention about when you're at step 1, there's a number of what I would call minefields. I talked a little bit about sometimes how to amend it is kind of the language that they have is a little bit unusual. Like they'll say 51% of the members at the meeting. There's also some other tricky language. Like sometimes it says in the documents that any amendments need to be acknowledged by, and then they give the percentage of owners, like acknowledged by 75% of the owners. What that means is that the signature of the owner on the ballot approving the amendment needs to be notarized. And there was actually very recently, within the past 60 days, there was a decision that was decided by the Arizona Court of Appeals that another law firm told their association, you don't really need to get those signatures notarized, even though it says that the document has to be acknowledged. The ballot had to be acknowledged, signatures of a certain percentage. And the Court of Appeals said, wait a minute, that's not right. The document says that it has to be acknowledged. It has to be acknowledged, and that means it has to be notarized. So make sure you're getting some advice on step 1. Okay, step 2, this is the easy step. Come up with the changes. The board can do it, your attorney can do it, the board and your attorney can work together with what the changes that you propose. The best way to do this is to redline a document and to have the existing document in the system and then redline it with the changes. And typically we go back and forth maybe once or twice with the changes. I give my comments, the board gives comments, we work together, and then we get a good document. Step 3 is the step that boards always want to skip. So at step 2, we come up with, here are the changes, it looks really pretty, we've got it in a red line document, everybody's excited. Now we want to take it to the members to vote. No, not yet. A really good strategy is don't forget step 3. Step 3 is getting the support of the community before the vote, getting their input before the vote. So step 3, educate and solicit community support for the change. The best way to do that is to send it out to owners with a comment sheet and say, here's what we're thinking about doing. What do you think? And then you probably will have very few people that will respond, But the ones that do always have some good feedback for us, like they absolutely hate what you're going to do on something. It's important for you to listen to that feedback, because if you have a really high percentage of approval that's required, if you have one or two complaining about it at this early step 3 stage, it typically means you're going to have 10%, 15%. They're going to say, I don't want that in the final draft. So at this point, we get the solicit the input from the homeowners. And what we typically will do is we'll send out a comment sheet. We ask for the comment sheets back within 30 days. We look at the comments. I strategize with the board and say, here's what I think you should do. If there's not a lot of comments and there's not a lot of hot button controversial things, we send it out as an all yes or no vote on the ballot. Either you vote yes for it or you don't. That's typically when people aren't upset about things. If there's some hot button issues like rental restrictions, there's all kinds of increasing the assessment rate without a vote of the membership. There's just things that I know from doing this for a long time. I know it's going to really get people bent out of joint. If you have some of those provisions in there, there's 2 things you can do. Throw them out, don't put them in before you send it to the homeowners for the vote, or separate it out and have them vote on it separate, so that you don't tank the whole document just because there's one thing that people don't like. So at this point, step 3, we get the homeowner feedback and then we strategize as to what should go into the final document. And if we could go to the next slide, please. The next step is step 4, and this is actually kind of the easy step. This is going to be where we develop the plan for how we're going to get the votes out and how long we're going to have this issue outstanding, the vote outstanding in the association. And your association knows best how long it's going to take. I have some associations in Sun City West that they have gotten 150 votes in a week, okay? And then I have other associations in other parts of the valley where it took us 2 years to get 150 votes. So it just depends. You know your community best. I can give you my feedback in terms of, okay, typically we like to put it out there for about 3 months, and then we can extend it if we need to. We don't want to make it too long that people put it in a pile that they never come back to, but you also don't want to make it so short that people will be calling upset that you're not giving them enough time. So at this point, basically, the homeowners have already seen it once. Now we're just asking for your vote. A good strategy point on step 4 is if you took out any of the hot button items, make sure you tell them that. We listened. Thank you for your feedback. We listened. We removed the rental restriction. Or we took out the provision that would allow the board to increase the assessment rate up to 10% of the prior year's assessment without a vote of the membership. We listened to you, okay, so that they're not like, don't make them guess. Tell them straight up, this is what we did. And typically we're sending out a ballot. It's a good idea to give them a self-addressed and stamped envelope. Give them a way to return it by email if you can. Just make it easy for them to return the ballot. And then the last step is, one other thing on this, step 4. If you're having trouble getting owners to vote, you should be evaluating what you're doing every 30 days and coming up with a new strategy to get ballots back. So typically we send out the ballot, and I would say 40 to 50% of the owners respond right away. And that's typically within the first 2 weeks. And then, maybe at the 30-day mark, we say, okay, we've got 50%, we still need to get another 25%. Let's send out a letter to those who haven't voted, reminding them, giving them another ballot. And then maybe that pushes you up to like 68%. And then maybe you got to do phone calls and knocking on doors. So every 30 days, evaluate what's working, what's not working, so that you can get the maximum participation. One thing alone typically doesn't work. Like just sending out one letter with the ballot once, that's not going to do it. Know that going in. You're probably going to have to do 2 or 3 letters, and then it's blood, sweat, and tears. It's knocking on doors, phone calls. It's not easy, especially if their ballots need to be notarized. What some of my clients have done on the notarizing is they just get the yes or no vote first, and then if it passes, if they get the 75% that they need, then they go back and they bring a notary to the property and they have people come out and sign in, over a weekend, Good Saturday and Sunday, they park a notary at the pool, and they have people, just sign the actual formal approval and have it notarized right then and there. Because who knows, they may never get the 75% if you have to have everybody notarize it on the front end.
Okay, so if you have each resident, each owner has to notarize their ballot.
Only if your association's documents state that the ballots or the votes of the owners need to be acknowledged.
Okay.
Most don't have that language. As a matter of fact, if we're doing an amendment and you have it, we take it out.
Okay.
But you still have to take it out, you still have to have the ballots notarized.
Okay, so when do you run into cases where one resident might get, or one owner might get multiple ballots and turn around and send them all in? Does that ever become an issue?
It does, but we keep, what our firm does is we do an Excel spreadsheet, and when the ballot's returned, we log it on the Excel spreadsheet. So if they've already voted once, we'll clip the secondary votes to it, just for paper trail and for good record keeping. The only time it becomes problematic is if they change their vote. Then we typically will say latest vote prevails. Okay? Okay, the last step is you get the votes that you need. Woohoo! And now we just need to finalize and record the amendment. So there's a very important time deadline. We only have 30 days from the date that the amendment is passed. So once we get that last signature that puts us over the percentage that we need, we have 30 days to get the amendment recorded under the law. And so your attorney will be, monitoring this. I've got it on the Excel spreadsheet. We know exactly when we hit that goal. And then we need the president and the secretary to sign the actual amendment. Their signatures need to be notarized, and then we record the document with the Maricopa County Recorder's Office. And then we notify the homeowners that the new amendment has been recorded. We make sure that you notify your management company that it's been recorded so that they give new buyers the right document, and you're done. So, and all of that is online. Bylaws do not need to be recorded. Articles of incorporation are filed with the Corporation Commission. They're not recorded. So really the only thing that gets recorded is the CC&Rs. The bylaws and the rules just go in the association's books and records. And the articles, if those are amended, those get filed with the Corporation Commission. Yes?
If we said that the CCR is a contract, do rules have to be tied in somehow to the contract? Does it have a separate piece of paper that says rules?
I like having it separate. So if you're going to do rules for your association, don't incorporate them in your documents, because then you have to, when you amend them, they have to be amended the same way that the document would be amended. So do them as a separate document. Typically the board approves the rules. Make sure you have legal counsel review the rules to make sure that there's nothing that conflicts with other documents or that is problematic, like discriminatory language, that type of thing. Okay, if you could advance to the next slide, which is our last slide. I just wanted to remind you of a couple things. First, our firm, I teach these classes for free, and I've been doing it for a long time. I love doing it because I think it's really important to get information out to homeowners and to board members. We do an email blast once a month. If you want to be added to that, just email me or sign up through our website. Basically, we just give you good information regarding new laws, seminars that we're having, case law that happens, tips, that type of thing. I think we have something like 9,000 people now on our list or something crazy like that. So it's very popular. People ask for that often, so I thought I'd mention it. The other thing is we have a First Friday free call-in. So if you ever have a question, whether you're a client of our firm or not, the first Friday of every month, we have a free call-in between 9 a.m. and 10 a.m. You're welcome to call our firm. The next one's September 1st. And you can ask any question free of charge. And we have all of our attorneys on team that morning, and we all answer your questions. So keep that in mind as a free resource. We also are on Facebook and Twitter. If you follow us on Facebook, we also provide tips every week and interesting articles on associations. I posted the one this morning about the sign. And last but not least, our website has a ton of free information. I'm really, really into education for board members and homeowners, so I encourage you to look at it. If you have a question and it's not on there, tell me, I'll write something on it. So we really try to have good information on there for you. Yes?
Real quick, given today's environment, vendors, landscapers, pool people, do we have any liability as an association as to their legal or employment status?
So are you talking about like maybe possibly not, like, so if any of your vendors are hiring people that may not have proper documentation? Well, I think to protect yourself, you should send a letter. If you're fearful that this is occurring, you should send a letter to the vendor and just say, you know, we've hired you to be our whatever landscaping company, and we are assuming that you are fully complying with all, you know, state and federal requirements, you know, and just leave it at that. And that should be adequate protection for you. Very good question.
Okay, thank you.
Yes?
I have one more question.
Sure.
Our property borders are very popular. And we have a few parking places, and we've noticed that people are coming across the street and parking in those parking places. Is there liability? So if the person comes over and is not a resident, parks in the parking area, which is basically the trespassing, falls and hits their head and gets hurt, are we liable for their?
Well, there are different standards of care based upon whether someone's an owner, whether they're a visitor, whether they're a trespasser. I mean, I guess the short answer would be that the association carries premises liability insurance. And if somebody does have an accident on your common areas, you know, our standard of care and the condition of the property will be evaluated. A claim will likely be made on the association's insurance, regardless, whether they're a trespasser, whether they're an owner, whether they're a visitor, whether they're authorized to be there or not authorized to be there. I mean, that's why we carry premises liability insurance. But you should be posting no trespassing signs if you feel that there are people that are parking in violation on your property. And, you know, I know that you guys have pretty active parking and towing policies within your association. You should be looking to your documents to deal with those cars that are not properly parked in your neighborhood. And by posting signs that the vehicles will be towed, that should basically eliminate the problem right there. Okay? Yes?
Right, at this point in time, there's no posting everything on the internet isn't considered, I mean, like you said, for meetings and stuff?
It's valid. Yep.
Oh, it is?
Yeah, oh yeah.
Oh, okay.
Most of our clients are posting on web pages for the association. Some are doing it on Nextdoor.
Okay.
Some are doing emails to owners to let them know when the meetings are. You know, I think that most people are trying to do it in a way that they don't have to spend any money in terms of postage to mail it. So I don't think I have any clients right now that are mailing the notices unless it's the annual meeting notice, which must be mailed, and special meetings of the membership, which must be mailed.
Oh, they do?
Yes, you do. Under the law, annual meeting notices must be mailed to the owners at their
I knew
address.
that one, I just didn't know about special meetings.
Special meetings of the owners, like a removal meeting, you know, if there's a meeting to remove the board, it doesn't happen very often, but you still need to follow the same formalities. Yes, did you have a question? Yes, yes.
If I told you that I lived in a two-bedroom, bath and a half ton, there are about 30 units, you got a pool and jacuzzi and covered off-street parking, what would you guess my HOA dues to be?
Oh, that's a tough one. So you live in a condo, you have a pool, you have off-street covered parking, small number of units, which is going to make the assessments go up. I'd say probably $400 a month. What are they?
209.
209. Okay, that's pretty low.
That's why we don't have reserve.
Yeah, that's probably why you don't have a reserve. If it was 400.
No, because this is something we need to take action on. We didn't know what other people were having. We had no idea.
You know, what you could do is ask the associations that are around you that are similarly situated what they're charging, that have similar amenities. That's probably would be a good first indicator. You should also get a reserve study done, so they tell you how much you should be putting in your reserve, and then you should be putting aside that amount of money every month so that you build up your reserve. Yes?
When there are condos and they have patios that are actually owned
At that point, when you have a landlord that has a lot of violations on their property, we have a very specific strategy we use in our firm. I call the landlord and I say, listen, here's the situation. You've got all these violations on your property. I know you're running a business, right? And as a business owner, I need to inform you that here's the next business step we're going to take. We're going to continue to fine you. We are going to file a lawsuit against you, and that is going to result in at least $5,000 in attorney's fees. And you know, I'm warning you, this, I know you're trying to make money with your tenant, but it's going to end up costing you more than, you know, whatever you're making on this particular tenancy. And I would say with 100% certainty, the landlord gets it because they're a business person, and typically either the tenant vacates or they ask me, will you evict them for me? Or, you know, the tenant cleans up their act and things get better. That's the best strategy. If you can't get it through compliance, voluntary compliance, and the fines that the board's levying aren't going anywhere, get the attorney to call.
And is that still the same case if it's Section 8?
Yes, actually it's better. If it's Section 8, better. Because you can call the Section 8 office and they will get rid of that tenant for you. You call the Section 8 tenant and they are way more strict than anybody. If there's any problem with that Section 8 tenant, that tenant's evicted.
Yeah, just document everything, tell the landlord if you don't get rid of them, we're gonna find you all this. You just get rid of them.
Okay, thank you everybody for coming. One more question and then I have to run because I have one of my kids has a spelling test tomorrow and he needs to do better than he did last week.
This is really, you said something about some laws that changed in the CCNRs. The CCNRs say that you can't have, like solar dishes and,
Well, just over the years, there have been a number of laws. Look at the top 10 cheat sheet that I gave you. That summarizes a lot of them. Or you're welcome if your association, you know, wants us to take a quick spin for free through your documents, and I can tell you, okay, these are the things that I think are problematic in a 5-minute phone call.
laws that have changed on that now too.
Oh, yes. There every year for the past 20 years, there have been multiple laws every single year. Okay? Start by looking at our website. We document all the laws on there. Okay, thanks everybody for coming. Have a nice evening.
Thank you.